when you look at this specific matter, this grooming policy that Achimota has, the judge asked the question, well, what is the objective of that? What is that for? Achimota could never give a convincing answer. They kept throwing things like discipline and academic achievement and hygiene and so on. But they were never able to demonstrate that just merely because of the style of your hair, you are likely to trigger indiscipline, or the learning environment is going to be negatively affected, or any dysfunctional actions would ensue as a result of that.
The judge actually said Achimota and the state did not answer that question.
Yeah, and there's a good reason they didn't answer that question, because there's no answer. It's just platitude, discipline, this, that. It doesn't mean anything. You got to show how discipline is affected by someone's hair. And so we on social media, we were even surprised that the Attorney General was defending this, because if you just went on to read a few cases around the world, you would have come to the inevitable conclusion that this restriction was not going to be allowed. Now, Samson, the other thing that, I've said that this ruling, for instance, does not mean that traditionalists or somebody can go to a math class and say, well, my religion requires me to slaughter a sheep. And so here I am, I'm going to slaughter a sheep. That's nonsensical. Or people sometimes say, well, people will go and smoke weed. Smoking weed is illegal. And so what is the basis for even thinking that way? It surprises me when people make some of these arguments, and people should actually sit down and read the judgment. If you read the judgment, all the floodgate arguments would go away. I have a few quibbles with the decision. Number one, I was disappointed that the judge did not award compensation. And the theory she advances is that, well, the students and the school are going to have ongoing relationships, and so compensation may not be proper. I disagree, because compensation is something that is awarded as a result of a past transgression. As a result of denying these guys 2 months of education, we cannot just say, well, let's pretend nothing happened, come to school and let's get along. No, if you do that, not only are you taking away from the kids, but you are also incentivizing the school to misbehave in the future. People learn, agencies learn, when there is a price for their misconduct. In Ghana, most of these administrative agencies are too careless when it comes to applying the law. They don't care very much about administrative rights, because they know even if you go to court and the court says, well, look, you couldn't do that, there's no cost beyond you couldn't do that. Judges should read carefully the case of Awuni versus West African Exams Council, where the Supreme Court imposed costs, and I would have wished the judge had imposed costs on that. The second thing was, I thought in such a case, it was clear that the harm that will be done to the boys by not allowing them to go to school will be irreparable. So Tyrone and Ohiniba showed up in school yesterday, and they had to go write an exam. Well, how are they going to write that exam if they've been denied education for 2 months? And in that regard, I would have wished the judge would have granted the applicant's injunction, injunct the school and allowed the boys to continue their education while the matter was still being heard. The third thing that I want to say is, I don't think the Attorney General must defend the clearly unconstitutional actions of administrative bodies. the Attorney General is also the Minister of Justice. And the Attorney General must have an interest in enforcing the Constitution, in ensuring that the constitutional commands are complied with. Sometimes it is very clear that an administrative body has violated the Constitution, and yet you see that the Attorney General will come to court, not just come to court, but come to court and make some outrageous claims. So, for instance, in this case, the Attorney General argued that the applicants had no capacity to sue, and the reason they had no capacity, according to the Attorney General, was because they had not yet accepted the admission. This is an outrageous claim. I mean, it's so frivolous.
But in respect of that contest by the Attorney General, do you think the manner in which the judge rendered herself is fair to the Attorney General? It sounds a bit like, you know, the